I'm joined now by two experienced death penalty attorneys, defense counsel Patrick Korody and veteran prosecutor Dan Skinner, director of the Homicide Division at the State Attorney's Office. Welcome, both of you.
Good morning, Ann.
Good morning. Thank you for having us.
Thanks for being here. So I want to make the most of the time we have on this complicated subject. So Dan, if you would, just give us a nickel version of what's happening. So death penalty cases for nearly a decade have been getting recycled and defendants resentenced because of changes to Florida's death penalty law. Why is that happening?
Yes, when the Hearst decision was handed down, the Supreme Court was telling us that at that time that unanimity is required by a jury. So, and ultimately, those cases that did not receive a verdict by a jury of 12-0, in other words, 7-5 all the way to 11-1, received a resentencing. That's what the Hearst court required. That has since been receded from in the Poole case, Poole, where that unanimity requirement now is only with respect to an aggravating factor.
So is the legislature moving the goalposts? I mean, initially there was no unanimity required from a jury. Then after 2016, jury unanimity was required. All of these cases coming up for resentencings. And now the law has changed yet again. The state says you don't have to have a unanimous verdict for death.
Yes, prior to the Hearst decision by the Florida Supreme Court and the U.S. Supreme Court, it was 7-5. That was a bare majority, and now it's a super majority. So it's more stringent than it was for many, many years. And under the 7-5 capital scheme, that's all that was required. So now today, with respect to where we sit, it is tougher than it was before. The aberration, from our viewpoint, was the Hearst case, and the Supreme Court reversed itself in Poole when it did require unanimity. So our position is the 8-4 is the law. It is what we're proceeding under. We're asking judges to proceed to these death penalty hearings, the resentencing hearings that are required by Hearst under the 8-4 capital sentencing statute.
Patrick Korody, this now makes Florida somewhat of an outlier nationally, though, not requiring a unanimous jury verdict and allowing something as like an 8-4 verdict. That is unique now to the United States.
Right. Well, it's unique to Florida. We are the outlier at 8-4. Alabama, I think, is 10-2. And then every other state in the union, which I think is around 25 states, plus the military and the federal government, that have a death penalty statute on the books, require a unanimous jury verdict for the death penalty to be imposed. Obviously, out of those 25 states and the federal government and the military, not all of them are actively using their death penalty statute or executing people. But, you know, Florida is one of the states where we are actively using our statute. We are actively executing people, and we are the outlier at 8-4.
So you handle death penalty cases. You've handled a number of cases with Dan here even. How did this reversal, how is it impacting your ability to represent these clients? How does it impact their chances of either getting a life sentence versus death on a resentencing?
So that's a really good question. We are doing the same things that we have been doing since the death penalty litigation restarted again after the Hearst decision in 2016. And, you know, I will say that statewide, I think that after Hearst, there was a big push for training capital legal teams. We're getting better at things like mitigation. I think the science that's involved in mitigation, brain science, has gotten a lot
Explain what
better.
mitigation is. Not everybody will know. But that in a death penalty case, what's the significance of what's called mitigation?
Sure. So what the jury's instructed is that the decision basically on whether someone who's been convicted of first-degree murder and now capital sexual battery in the state of Florida, that's something new also, but whether or not that defendant who's now been convicted, you move to a penalty phase, so there's no question as to whether or not they're guilty or innocent. They have been found guilty. And then the question largely becomes a weighing process as to what is aggravation regarding the crime, weighed against mitigation, which is essentially anything in a defendant's background, character, or the crime itself that may be a reason not to impose a death sentence. And the only alternative under Florida's law to a death sentence is a life sentence in prison without the possibility of parole. So mitigation could be things like a difficult childhood, that the defendant has a brain injury, that the defendant may have low intellectual function, but not at the level that would bar execution. They have to be intellectually disabled to not be executed under the laws of the United States. But mitigation could be anything. Mitigation could be that they were a good son, a good brother, a good sister. And in a lot of these Hearst cases, especially the ones that Dan and I have had, some of them are 15 or 20 years old, and the defendant comes back, and a lot of them have good records in prison. I mean, they've been in prison for 15 years, and they've had good behavior, and that's mitigation.
And when you say that defense teams have gotten better at mitigation, what do you mean?
Well, there's been a lot of training and a lot of expertise developed in the area as far as how you investigate it. There's been a lot of advances in using things like MRIs and PET scans to identify traumatic brain injury and other types of brain injuries. And so I think the lawyers and the people we use have gotten better at where to look for this evidence. And I think the science has advanced also in giving us more information to present to a jury.
And I know you think that there's other reasons that these cases have gone, for life on resentencing versus death. And I want to get to some of those in a minute. But Dan, I want to ask you, there was a recent study done by the Death Penalty Information Center that found of those Hearst cases, those are the cases that are required to come back before a jury to be resentenced because they weren't unanimous, that 82% of those were resentenced to life instead of death. What does that tell you about the legitimacy of the original sentence?
Sure, that's a great question too. Our position is when the Hearst decision was handed down, each respective state attorney's office in Florida received a monumental amount of work that comes back to them with no additional staff. So on top of prosecuting cases that we normally do, our office carries between 200 and 225 homicides at any given time. When Hearst came back, it added to that. In Duval County, Northeast Florida, we received back about 30 Hearst cases that we had to re-sentence. We think resentencing, and we think, well, that's just a hearing one afternoon. Well, it is not. As Mr. Korody has noted, the defense has gotten incredibly effective at the presentation of mitigation. They present it to us. Those cases, we now have a grand jury indictment review panel. When Ms. Nelson became state attorney, one of the first things she did was create that panel. That panel has about 150 years of prosecutorial experience on it. We review every single case for death penalty consideration. That is a first-degree murder. We do that based on what the legislature gives us with the aggravating factors and the mitigating circumstances. When those cases came back, we had to evaluate each and every one of those. Many we resolved for life. The defense, as Mr. Korody pointed out, presented that mitigation. It is much more in depth today than it was 15 or 20 years ago. So we review that and make a decision whether we should go forward.
In continuing to seek the death penalty.
That's correct. That is correct. And ultimately, one of the sort of factors in that consideration is talking to the victim's family. So they're getting a phone call from us and then several meetings thereafter where we kind of explain the process. And many of them are frustrated after years and years of having their convictions affirmed and their particular defendant that killed their loved one is on death row. When they came back, they're now under the impression that they have to do this all over again, which they did. And we tell them that because a resentencing is not just an afternoon of putting on aggravation and mitigation. It's selecting a whole new jury. It's presenting the case anew as if that jury never heard the facts because they have not. It's a jury today. So ultimately, when we explain that to victims' families, many of them just tell us, I can't do that again. It's too emotional. It was 15, 17, 12, 18 years ago. And they, in a lot of these cases, particularly the Hearst cases we're talking about, they ask us to take the life sentence recommendation. They ask us to go to the court and represent on behalf of the state of Florida that we're recommending a life sentence, and we've done that. The heaviest calculus in that whole process is the victim's family's input. So that's very important to us. One other consideration that's very troubling in all the Hearst cases, many of the detectives, many of the analysts, the FDLE analysts, they're retired. They no longer work in law enforcement. They're difficult to track down with respect to civilian witnesses. So putting these cases back together and having to, in essence, put on the entire case again times 30, which we had in Duval County, was a monumental task. So most certainly we sat down as a committee, and there are 9 of us on our committee and Ms. Nelson's grand jury indictment review panel, and we discussed those. And we put all that on the table and make the decision of whether we should continue to seek the death penalty. Many of those cases, we did make the decision ourselves without putting the burden on a court or a jury, based on the mitigation, the victim's family's wishes, the absence of witnesses to resolve those cases for life.
How many of those 30 cases did you resolve without taking it to court?
I think the exact number was 29. We've probably taken to trial or resentencing, as it's called, in about 8 of those. And we still, in fact, there's one going this week. So that number is obviously fluid. The Cecil King case is going this week. It's also a Hearst resentencing. So
Remind us the circumstances of Cecil King.
sure, that was a elderly female who was killed by an individual. I believe the vote was 8-4. That obviously required a new sentencing hearing under Hearst. So that's proceeding back to a trial this week. That was a case that happened of a family that lived off a quiet neighborhood off of Bay Meadows Road, where an elderly female was killed. The defendant went to trial, was found guilty, and ultimately was sent back just for one of these Hearst resentencings. I believe that case was from 2012, so that's a decade ago. We were able to piece that one back together. Mr. Bernie De La Rianda is trying that on behalf of the state. So it's, again, a very difficult situation trying to put cases back together and hail witnesses back to court and get them to come in and testify.
And what about that case merits going for the death penalty a second time?
Sure, I can't speak to the specifics, but I know the family was very cooperative in that particular case. It's pending now, so we won't go into any individual conversations with them, but they were very cooperative with us and wanted to proceed. Ultimately, that is one of the heaviest factors. Mr. Korody and I have had 2 cases personally that we've dealt with under the Hearst context, and one of those families was adamant not to proceed, and one of those families that I had was adamant that we do proceed. One of those, Mr. Korody and I, in a case called Robert Peterson, we tried that case early last year in a Hearst context. So the other one, Justin McMillan, we resolved for life. The family was extremely insistent that we resolve that case. So it really is one of the driving factors that helps us in reaching our decision.
And sometimes family members don't support going back to trial, but you still do. I know that in the case of those 3 defendants who were convicted of burying an elderly couple alive, the daughter, who's the closest relative to the 2 elderly adults, doesn't support the death penalty. In fact, has become an advocate for death row inmates. So how do you negotiate that?
Sure, and that's why the state of Florida has to make the ultimate decision. We've had immediate family members where a husband and wife of a deceased daughter of theirs, one wants the death penalty and the other does not. So when you have equal next of kin in those situations, ultimately we have to make that decision to move forward. That sort of prompts us to do that analysis with respect to weighing those aggravating factors versus the mitigation that the defense provides to us.
Patrick, you've talked about, mitigation has gotten better, perhaps lawyering has gotten better, views have evolved on the death penalty. But what do you think is the primary reason that the cases have gotten harder in terms of achieving a death penalty?
So I do think that people maybe see more hope for redemption and remorse than maybe they did 10 years ago. I don't know if COVID had anything to do with that. I'm not, a sociologist or a psychologist, but I do think that there have also been a change of demographics in Jacksonville. I can tell you that when I'm picking a jury these days, the majority of the people that you're picking from are not from Jacksonville originally. There are a lot of people that have moved to Jacksonville. So you have a lot of people that are newer to Jacksonville, and maybe the demographics and views on death have changed.
It doesn't seem fair fundamentally that some people were given a life sentence under the requirement for unanimity because the jury wasn't unanimous, and even just months later somebody received death, even in the same crime, the one that we were just referencing, that awful buried alive case. The defendants had similar jury verdicts, that one got life and one got death.
So, and I represented Tiffany Cole, who was part of that. What was interesting is there were 3 defendants that got resentencings. The first one, Alan Wade proceeded. He proceeded under the unanimity statute. So 12-0 if they wanted to obtain a death sentence for him. He got life. And then later, interesting that Michael Jackson and Alan Wade were joined together to go together. And then they were severed during jury selection. So Michael Jackson, was going to go later. By the time Mr. Jackson went, I think the statute had changed. And so he now, faced the 8-4 statute. And then when we tried Tiffany Cole, she faced 8-4. Mr. Jackson got death, and I believe the vote was 8-4. So if he had gone under unanimity, he would have gotten a life sentence.
And sort of ironic that he requested to sever. I mean, that was the defendant's decision. Dan, just briefly, is it fair? I mean, is it fair that you're having cases where literally within a matter of months, it's either life or death based on the same facts and the same jury verdict?
Well, it works both ways. I tried a case in February, and the jury vote was 10-2 when it was unanimity. And then the law changed a couple months later where he would have received death. So he received the benefit of that particular statute in effect, that now that today it's clear the Poole Florida Supreme Court, their decision was we were wrong on Hearst. That was bad law. And the legislature came along and changed the law. Our governor signed that law into effect. Prosecutors, our job is to do one thing: enforce the law, seek justice for these families, enforce the law as it is on our books today. So yes, we do believe it is fair.
Well, Attorney Patrick Korody, Prosecutor Dan Skinner, thank you so much for being here. I appreciate it.
Thank you, Ann. Thank you very much.